I guess we'll go ahead and get started, and maybe some more are going to float in. So I'm going to mute everyone for the moment, and then I'll unmute you when we have our opportunities for questions. There's also a group chat function on Zoom that you can feel free to type questions on, and I will try to answer them as we go through. So thank you for coming to the webinar on Municipal Enhanced Energy Planning in Vermont, Best Practices and Resources. My name is Tori Littlefield. I'm a regional planner with the Two Rivers Ottaquiche Regional Commission. I know some of you on the list here, but for those that don't know me, I've been primarily working in emergency management and town planning the past 4 years, and I've recently taken on this new role of energy planning since Dee Gish has left us. So we'll get started. So just an overview of the presentation tonight. The first section of the presentation, I will walk you through developing a municipal enhanced energy plan that includes preparation, practical advice, plan requirements, the adoption process, and how to implement your new enhanced energy plan. The implementation piece is especially important to pay attention to, as the focus of these plans, going forward, we'll be implementing them to meet the state's energy goals for those that do have enhanced energy plans. The second part of this presentation, I will walk you through how these adopted enhanced energy plans relate to the Section 248 process and, how they act in that. Oops, sorry. And I will take questions at the end of each section. And feel free to use the chat, and then I'll unmute if you have your microphone or a phone hooked up to this presentation. I'm anticipating this presentation to take about an hour, and this is a somewhat complicated topic, so it may be possible that we might go over the time. And I will also be emailing out a recording of this presentation to you as well. Okay, so to begin, developing a municipal enhanced energy plan. Sorry, I'm having some technical difficulties. Okay, so just some background information on what Act 174 is and how the enhanced energy plans came out of that. So the Municipal Enhanced Energy Plan process was developed by the Public Utilities Commission as a result of Act 174. Act 174 of 2016 establishes a new set of municipal and regional energy planning standards, which, if met, allow those plans to carry greater weight, called substantial deference, in the Section 248 siting process for energy generation. Meeting the standards is entirely voluntary. If regions and municipalities do not wish to update their plans, they will continue to receive due consideration in the Section 248 process. Vermont's energy goals, as outlined in the 2016 Comprehensive Energy Plan, calls for Vermont covering 90% of its total energy demand from renewable sources by the year 2050. As you can see in the graphic on this slide, Vermont's energy goals are staggered from now until the year 2050. In 2025, which is only 5 short years away, Vermont should get 25% of its energy needs from renewable sources. They also broke this goal out for end-use sectors. So transportation should be 10% renewable, buildings should be 30% renewable, and electric power at 67% renewably sourced by the year 2050. And when the Comprehensive Energy Plan was published in 2016, Two Rivers was one of 3 regional commissions in Vermont to develop an enhanced energy plan at the regional level. This was adopted in 2017 and was deemed to meet the energy planning standards by the Public Utilities Commission, which are the same standards that municipal plans must adhere to. And I'm going to talk about that more in a bit. And I see that Annette put in the comments that X 174 was developed by the Department of Public Service, which is now the Public Utility Commission. So that's a good point to make. Thank you for that. So plan preparation. In order to start preparing your plan, you must have the local capacity and the local interest in developing an enhanced energy plan. The enhanced energy plans, as mentioned previously, are not statutorily required, but it is rather an option to give your community a leg up on what types of energy development you would like to see in your town. Staff at Two Rivers are a great and often free resource to assist your planning commission or energy committee, if you have one, to develop one of these plans. I say we are often a free resources to assist you with developing your plan, as we can provide you sample text and can conduct reviews of your plan before you go through the adoption process. The last 3 years, Two Rivers has received funding from the Public Utilities Commission to assist communities in developing these energy plans up to the draft stage. We've worked with about half of our 30 towns in doing so, and so far only 2 have gone completely through the adoption process. But we are anticipating more towns will soon seek this energy determination from the Regional Commission. Building local consensus on this type of plan is also necessary. It's not unusual for residents of your town to get passionate about energy development and where you can't develop wind towers, hydroelectric dams, and solar fields. It is good to start this process with the public as early and often as you can manage, so there are no surprises during the public hearing stage. And understanding the requirements of an enhanced energy plan is one of the most important items before you start writing your plan. There are a lot of standards and requirements are not always clear. This is where Two Rivers can help you as well. We are always willing to come to a meeting to explain the process to you and to go through the standards, as well as providing sample text, data, and maps in order to meet the standards. And also the Public Utility Commission has been willing in the past to meet with communities on the enhanced energy process as well. And since many enhanced energy plans are incorporated into your town plan, it is important to review your existing town plan to identify any inconsistencies with statute. This is another area where we can assist. We review all town plans and make the plans available on our website as a resource. We are also willing to do a quick review to see if there are any statutory elements or goals that need to be expanded or added. Many of you know that recent new statutory requirements related to forest blocks and flood resilience were recently added in the past few years, and that those 2 subject items will need to be incorporated into your town plan as you are developing your enhanced energy plan, if they aren't already. And as a final note on this slide, reviewing other enhanced energy plans in the region or throughout the state can help you visualize what one of these plans are supposed to look like. At the time of this presentation, only the towns of Braintree and Woodstock have an adopted enhanced energy plan in the Two Rivers region, with several more anticipated in the coming months. These are all listed on our website, and if you want to see plans from other towns in the state, the Vermont Association of Planning and Development Agencies has a list on their website of other communities that have an adopted and approved enhanced energy plan that meets the standards. And plan preparation. So when you are ready to start preparing your plan, you need to decide if it will be a standalone plan or integrated into your town plan. It is often easier to integrate into your town plan, but you also have to understand that this opens up the rest of the town plan for review, adoption, and approval, and then it has to be 100% compliant with statute. Your town should determine who should be writing the plan as well. If you have an energy committee, you can pass this responsibility to them to come up with a draft. Or if you do not have an energy committee, the planning commission is often the one to write it. If your energy committee is the entity to write your enhanced energy plan, it is strongly advisable that they work closely with the planning commission on the draft. There have been instances when well-intentioned energy committees wrote an energy plan that the planning commission wanted to completely rewrite or send back to the energy committee to rewrite. So it's really good to have that transparency with other committees and boards in your community. And developing a schedule is critical, as it can help you stay on track and to not have your drafting stage churn for a long period of time. When I work with a community on their energy plan, I typically take about 5 or 6 meetings to draft it and then allow the planning commission or energy committee a couple more meetings to fine tune details and mull things over. Plan requirements, analysis, and targets. Data, data, data. This is perhaps one of the most important pieces of your enhanced energy plan. And luckily for you all, we have already provided the required data for your community. This information was sent back to your town back in April 2017, but in case you no longer have this packet, it is also listed on our website on your individual town's page. This data is a mix of state and federal data. It's not something we created ourselves. We just kind of grabbed the data from different sources and curated it to your specific community. And since these packets were made over 2 years ago, when you are going through your enhanced energy plan, we are more than willing to update the data in these packets for you. Section 4 of the Energy Planning Standards requires that enhanced energy plans must contain an analysis of resources, needs, scarcities, costs, and problems within the municipality across all energy sectors, electric, thermal, and transportation. Towns can meet this standard by using the analysis and targets provided by Two Rivers. The Community Energy Dashboard is another important data resource for your plan. It can show you how many renewable energy projects are in your community, as well as the town's progress to meeting the energy goals. And these energy plans can also become dense and unreadable. I'm sorry, I'm having issues. But so you can get bogged down in the data pretty easily. So it's always good to add graphics that you can add to your plan to break up the text and the data. And that's something we can provide for you, or you can generate them yourself to help showcase the data and goals that you're trying to reach for the general public. And as I said before, some often really get mixed up in the data, but you don't have to be super accurate with it. Estimates are okay to use, and it will meet the standards. And typically, federal and state data is really difficult for our small rural communities to have the most accurate data possible. So that's another area where estimates are okay. And we are also anticipating a whole new rollout of data in 2021 when the new Comprehensive Energy Plan is released. Plan requirements, pathways. You may already have existing policies that meet the standards. Your enhanced energy plan will touch upon multiple elements such as land use, housing, transportation, energy, utilities, and facilities. I always tout plagiarism when it comes to town planning. It's perfectly okay to beg, borrow, and steal from other town plans in your region or in the state for language and ideas on policies. Or you can just contact your regional planning commission, which is me, and then we can give you examples of what other towns have done if you don't want to do that digging on your own. The giant circle graphic on this slide is one of those that we can make for you to kind of ground your senses of how much renewable energy generation that the state is asking you to do to help them meet the goals. This particular example is one that I made for the town of Randolph when I was working with them on their town plan. So the state is saying that the town of Randolph must develop 184 acres of renewable energy in order to meet the state goal. And this particular example is related to solar. So, on the ground, when you're first hearing that number, that is a lot of land. But if you kind of broaden that out, the town has 31,000 acres of land. 8,700 acres are considered to have the potential for solar development, but out of that, you only need 184 acres. So the gray circle is representing the total land area for the town, while the yellow circle is the solar potential at 8,700 acres approximately. The green circle is the goal that the town has to meet for the 2050 goal. And then that blue circle in there at that time was how much that the town already had built since September 2016, which was about 18.2 acres. So this is kind of a cool graphic. You can put it in your plan, which I believe the town of Randolph did, or it's just kind of an exercise to go through when we're working through the enhanced energy plan. Or you could do something cool like the town of Dorset did in this slide. They put several pictures of what different size arrays look like. Because if you say 4.7 kilowatts, you might not know how big that is, but looking at that picture, you can see, oh, that's what that looks like, and then you can see what 1 megawatt looks like to kind of visualize, what that could potentially be. And one suggestion of implementing energy saving practices would be for towns to budget for thermal efficiency upgrades to municipal buildings or building a solar facility on town land. Energy saving measures can be integrated into a town's capital budget. Okay, and then the mapping piece is the last plan requirement for the enhanced energy plan. So this is part of the energy data packet that we made for all of our towns. We just did kind of generic 5 maps that show you your existing energy generation, your biomass potential, your hydroelectric potential, solar and wind potential in your specific community. These are important to review because these are potential development areas for each type of renewable energy. And we are also more than happy to provide you large poster-sized printouts of these maps when you're working through them as well. You just have to ask, and we're totally willing to send you those. And the maps are often the most contentious parts of the enhanced energy plans because you have the opportunity to clip out areas that you deem unsuitable for renewable energy development. So this is where the public often gets involved. They get pretty passionate, like they don't want solar in the backyard, for example, or they don't want solar over there, vice versa. Some communities use their zoning districts as guides to clip these out if you have zoning. And some in the state have gone parcel by parcel to determine, what is appropriate where, and that is pretty tedious. Overall, this process is called selecting your preferred sites. Preferred sites give renewable energy developments greater financial incentives to build systems where the state and towns would like. Sorry, it's not happy with me. All right. And this part of the plan is also where clear policy statements are critical. Right now, towns are allowed to state that by a joint letter of the Planning Commission and Select Board and the Regional Planning Commission, a site is deemed preferred. The joint letter of support provision may change as the Public Utilities Commission is currently reviewing the net metering guidelines of Rule 5.100. Rochester, which is in this slide as an example, chose to write no renewable energy generation along the Braintree Ridge and in one of their zoning districts. The more specific you are, the less chance it could be misconstrued in the future. You also cannot pick and choose what types of renewable energy developments are allowed where. The policies that you write are relevant to all renewable energy, wind, biomass, hydro, and solar. It was also ruled by the Public Utilities Commission that you cannot completely ban renewable energy development in your town. You must provide enough developable land to meet your energy generation target. And then a little more on preferred sites. I touched on this in the last slide, but at the moment you can write specific locations as preferred sites in your plan or create a process or criteria for determining what sites may be deemed preferred by joint letter of the Planning Commission and Select Board. And as I stated, the state is currently reviewing the net metering rule, including preferred siting. And this could mean that the whole town is preferred, or you could be more specific. Basically, you have the ultimate freedom and jurisdiction to decide where in your town renewable energy development is allowed. And on this slide, which I'll send out with the recording, is a link to Vermont's net metering rules, which you can take a look at on your own time, as it's pretty long and dense. And then plan adoption. So if you've managed to get to the adoption process at this point, that's awesome. Your energy plan must be consistent with the municipal plan, and that municipal plan must be compliant with statute and the regional plan. This is another area where local support is much needed. Don't get to the hearing stage unless you've had some public forums on the topic, especially related to renewable siting. I've often seen town plans fold because the public was not aware of what was being proposed in the plan until it got to the hearing stage. And after the plan has been adopted by the Select Board, it then goes into Regional Planning Commission review. We will do a regular review of the town plan and weigh it against the statutory requirements, as well as do a separate review of the energy standards to make sure the plan meets them all. After staff does their write-up, those write-ups are passed to our board of directors where they vote on approving the town plan and then vote on the enhanced energy determination. The PUC requires that you have an approvable town plan before you receive your determination of energy compliance. Once that is formally approved, our board will issue a letter to your community stating you have received a determination of energy compliance. And then the PUC will also receive a copy of this notice. So I highly recommend that you ask us to do an informal review of your plan before it even goes through the hearing process in case there are discrepancies between statute and the energy standards. And plan monitoring. To track progress on your town's energy efficiency and renewable energy targets, you can check the Vermont Energy Dashboard, where you can find information on the number and size of energy projects that have been completed in your town. And the community progress maps, that's a relatively new feature on the Vermont Energy Dashboard. So I highly recommend you check that out. And then plan implementation. So at this point, all of the 11 regional planning commissions have received a 3-year contract from the Vermont Energy Investment Corporation to work with Efficiency Vermont to start implementing these energy plans, including our own at the regional level. We just received this contract this past fall, and so far we have attended and helped host several button-up events, created an efficient home heating video, and will in the future be developing sample bylaws, supporting more energy committees, and setting up other events. This is a really cool opportunity for us because the past 3 years we have been energy planning, and now we get to take some action to help Vermont meet its energy goals. And some examples of how we are implementing our own regional energy plan is by signing on to a community solar project developed by Green Lantern Solar and installing an electric vehicle charging station at our offices for employee and visitor use. Many town energy committees in the Two Rivers region are hard at work, holding button-up events, working to complete community solar projects, and educating their communities about the benefits of energy efficiency and renewable energy. So I'm going to unmute everyone and in case there's any questions. I see there's been some chat. I apologize, I meant the Department of Public Service, not the Public Utilities Commission throughout all of the planning. So are there any questions so far on the enhanced energy planning?
This is Nancy.
Hi, Nancy.
Hi, you said that this was voluntary by the various towns.
Yes.
So how, if your town just decides, I'm not going to worry about any of this, what happens then?
I'm going to get into this a little bit, but yeah, the enhanced energy planning is a voluntary piece at the moment. I don't know if that's going to change in the future, so you don't have to do this, but if you don't have an enhanced energy plan, then you don't get what they call substantial deference, which is basically a seat at the table through Section 248 proceedings. Because right now, if there's a Section 248 permitting process going on in your community, then the Public Utilities Commission is not required to look at what you've written in your town plan.
Well, I guess I'm really confused about this in that regard. In looking at, I believe it was your site and what various planning commissions were doing, I am from Addison County, and as I recall, there was absolutely no activity there at the Regional Planning Commission.
It was not Addison County.
What? What did you say?
I don't think that was me, but yeah, I'm not sure what other regional planning commissions are doing. They're supposed to be doing the same things as us because we all have the same contract. So that might be a question out to your RPC. Are there any other questions before we move on? Oh, I see. Brooks, yeah, they do look at the town plans and it gives them due consideration, but they're not required to look at them. If you have substantial deference, then they're required to take all of your policies seriously.
So tell me why I want to sit and whatever for the section 248 process.
So it's going to go through, you know, how the section 248 process works. And then we're going to get into, if you do have an approved enhanced energy plan, then how that interacts with the section 248 process.
Okay, well, I guess I'm asking these questions because I'm expecting some resistance in general in the town. So I need to know and understand the ramifications of that.
Right, yep, and yep, that's what we're gonna get into right now. Okay, so I'm gonna remute everyone and then I'll take you off when we get to the end. All right, so municipal plans in the section 248 process. So the Vermont General Assembly, by enacting section 248 of Title 30, required companies to obtain approval from the Public Utility Commission before beginning site preparation or construction of electric transmission facilities, electric generation facilities, and certain gas pipelines within Vermont. The Public Utilities Commission is a quasi-judicial board that regulates electric power companies, telephone and cable television service providers, some water utilities, and gas pipeline companies. The Public Utility Commission also establishes rules and procedures related to utility matters, including procedures and adjudication of Section 248. The Vermont Department of Public Service represents the public interest in electricity, telecommunications, water, and wastewater matters. DPS is a statutory part to Section 248 proceedings and provides comments to the Public Utilities Commission in response to each application. So there are several different types of applications in the Section 248 proceedings. So net metering is something very common that most of us know about. So that means that this is the process of measuring the difference between the electricity supplied to a customer and the electricity fed back by a net metering renewable energy system during the customer's billing period. Net metering has allowed for the increase of renewable energy generation in Vermont due to the financial benefits of generating small-scale renewable energy. Net metering only applies to renewable energy generation less than or equal to 500 kilowatts of generating capacity. Rule 5.100 for net metering renewable energy system, which, as I mentioned, is currently under review, sets different category capacity factors and siting adjusters to incentivize renewable energy development in certain locations, as illustrated in the sidebar on this slide. There are also utility scale projects that include the Standard Offer Program and Public Utility Regulatory Policies Act. The Standard Offer Program promotes the rapid deployment of renewable generation facilities with a nameplate capacity of 2.2 megawatts or less. These large-scale projects pay renewable energy developers a fixed price for energy generation for up to 20 years. PURPA, the Power Purchase Agreements, Public Utility Regulatory Policies Act, PURPA, was originally passed with the intention of conserving electric energy, increasing efficiency in facilities and resources used by utility companies, and making retail rates for electric consumers more fair, speeding up the creation of hydroelectric energy production at small dams. Sorry, I'm not sure why that's doing that. And conserving natural gas. The main vehicle that the PURPA law used to try and accomplish these goals was by creating a new class of electric generating facilities called qualifying facilities. And PURPA gave these qualifying facilities special rate and regulatory treatment. So who can participate and how can you participate in Section 248? So there are formal parties to a case, and they're called interveners. They may provide the testimony, and they may participate in hearings. Formal parties to a case may not speak at public hearings and can only be heard through submission of written pre-filed testimony. So there's automatic formal parties, which includes the applicant, the Department of Public Service, the Agency of Natural Resources, the Regional Planning Commission that the project is within, and the municipality. All formal parties must follow the board rules, and they are all subject to discovery and cross-examination. And there's also interested persons. So they receive major notices and orders from the board. And then there are the members of the public. This is where they can speak at public hearings, they can send the board written comments, but they may not participate in hearings, and they may petition the board to become formal parties. It's a little confusing, and we're going to get into that a little bit later. And then the Public Utilities Commission has staff. Sorry. So 3 members of the Public Utilities Commission are appointed by the governor to serve staggered 6-year terms. They have a clerk office that have staff to administer paperwork. There's their legal division. Some act as hearing officers on smaller cases, and they also sit with the board in technical hearings. Their policy division act as hearing officers and participate with the board in technical hearings as well. The financial analysis division, some can act as hearing officers and participate with the board in technical hearings. And then their business office includes a business manager and administrative assistant to the chairman of the Public Utilities Commission. So what are the steps in the project? So net metering projects don't go through this whole process that I have on the bottom of the slide. Those are pretty much shot through the process. And those are systems, greater than 15 kilowatts are considered large net metering process. And those have to go through the Section 248 process, beginning with an application. And companies wishing to construct a renewable energy systems applies to the PUC for a certificate of public good. Applicants must also file a notice with a number of individuals and groups, including the Public Utilities Commission, Department of Public Service, the town where the project is proposed, and adjoining landowners 45 days prior to filing a formal application. And as a side note, Annette put in the chat that net metering projects can go through the full process if parties ask for a hearing as well. So the yellow graphic on this slide is we're going to go through each of these points in the preceding slides. So the 45-day notice is first. Then there's the filing with the Public Service or the Public Utilities Commission. This is an old graphic, sorry. They get signed a docket number, and a pre-hearing conference is scheduled and held. There's an intervention deadline. There could be up to 3 rounds of discovery and possibly depositions if it's a particularly controversial project. There could potentially be a site visit and a public hearing. There will be a public hearing. There's pre-filed testimony, direct rebuttal, and sur-rebuttal. There's the technical hearing, and then there's the briefs. And then after that, if it goes through all that, then the decision is issued. And Annette, thank you again. They call it a case number instead of a docket number now. So the 45-day notice, this is the best spot where a municipality can get involved in a case is when you receive your 45-day notice. So the developer, files a petition and oops, sorry, that's out. Sorry, ignore that last sentence. So the notice of no less than 45 days prior to the application is required. So that is before the developer issues a full application to the Public Utilities Commission. This is just kind of a notice that they are going to file an application. to the Public Utilities Commission. And this notice is going to the Regional Planning Commission, the municipality, and also the adjoining landowners. And this is where municipalities can take action. So you can organize, gather information on the project, and ask questions to the developer. Oftentimes the developer is very willing to hold a public hearing, usually with the Planning Commission, to take questions from the public and also from town officials on what the project is and what they're thinking, and kind of get a sense of the whole application. And this is where the municipality can submit comments, formal written comments to the applicant and the Public Utilities Commission, either in support of the project or against the project. In waiving the 45-day notice, you can use your judgment. The applicant sometimes, is taking a long time to prepare the notice, and that can get waived. Sorry, that's a bad note. So the pre-hearing conference. So the board will hold a pre-hearing conference to determine how the case will be managed. The board will generally identify potential parties, identify the issues necessary to resolve the case, and establish a schedule for the case, which includes the site visit, public hearing, deadlines for the filing of motions to intervene, discovery, the filing of pre-filed testimony, the evidentiary hearings, and briefs. Following the pre-hearing conference, the board will issue a pre-hearing conference memorandum that addresses the issues described above. The pre-hearing conference memorandum will also include a service list, which is a list of all parties and interested persons. And when filing letters, testimony, briefs, and all other materials provided to the board as a part of the proceedings, all parties, but not interested persons on the service list must be provided with copies. And all correspondence and filings must be addressed to the clerk, Public Utilities Commission, and it must refer to the case number. And this is another great place for a municipality to participate in the case. So intervention versus public comment. Typically, the next step after the pre-hearing conference is to determine who the formal parties to the case are. As explained earlier, some entities are automatically formal parties to a case. Other individuals or organizations may become formal parties as interveners if they meet certain criteria. Interveners have the same rights and obligations as the other formal parties, including the requirement that parties follow the Commission's procedural rules. An intervener may provide testimony and participate in the evidentiary hearings and will be subject to the rules governing discovery and cross-examination. In order to intervene, one must file a motion to intervene explaining the nature of the interests which may be affected by the outcome of the proceeding. Typically, motions to intervene must address the following standards. The person demonstrates substantial interest which may be adversely affected by the outcome of the case, whether the applicant's interests will be adequately protected by other parties, whether alternative means exist by which the applicant's interests can be protected, and whether intervention will unduly delay the proceeding or prejudice the interests of existing parties or the public. The motion to intervene, as well as any other filings in the case, must be filed with the board and all parties. Existing parties may comment on the intervention request, and the board will issue an order granting or denying the motion to intervene. In order to manage the case efficiently, the board may restrict an intervener's participation to the specific issue in which the intervener may be affected, or may require the parties to work cooperatively. Often, interveners are represented by an attorney. Individuals may, however, represent themselves without the assistance of counsel, a pro se representation. Additionally, the board may allow partnerships, corporations, and associations to be represented by an officer or an employee designated in writing by an officer of the corporation or association. It is important to understand that when individuals appear pro se, they have most of the rights and responsibilities of an attorney. If a pro se representative is unable to comply with its obligations under commission rules and Vermont law, the commission retains authority to require the party to retain counsel. Intervention should not be requested by a municipality without considerable thought, since participation requires considerable time, expertise, and potentially money if an attorney will represent the municipality. Here are some questions that a municipality should and might ask before deciding to intervene. May community concerns be resolved by revising project plans with the applicant during the 45-day notice period? What are the project's potential impacts, both positive and negative, to the community? What are the benefits of intervening? What are the costs? Which Section 248 criteria are of concern to the municipality? Will other parties that share the same interests? Is there a possibility to cooperate with these parties? What is the position of the Vermont Department of Public Service Public Advocate Division? What is the position of the Regional Planning Commission? Do their interests align with the municipality's interests? Will the legislative body support intervention and commit the required resources? And may other possible courses of action that could be more effective in influencing the project and meeting community concerns? Looking at, so I got a question. The PUC may require pro se parties to hire a lawyer. No, it did say that they may have a lawyer, they may not. They're not going to require them. I'm sorry if that misspoke or misconstrued. Okay, so the site visit and public hearing. So the site visit, the board will generally conduct a site visit to the affected area in order to get a better sense of possible impacts from the proposed project. The site visit will typically include a discussion of the following matters: a description of the proposed project and its location, a view of the existing conditions at the location of the proposed project, and an explanation of how the existing conditions would be altered by the proposed project. The site visit may also include identification of relevant landscape features, discussion of how such landscape features have affected or potentially should affect the project design and location, identification of and visits to potential alternative locations for the proposed project, and any other relevant matters for which a first-hand viewing of the site may assist in understanding the issues before the board. These site visits are not a part of the evidentiary record and are not relied upon in the final order, unless the commission enters observations or facts from the site visit into the record at the evidentiary hearings on its own motion or grants a party's request to do so. And then the public hearing. So Section 248 requires the board to hold a public hearing in at least one county in which the project is proposed if it crosses county boundaries, but typically projects are within one municipality. The purpose of the public hearing is to allow the board to hear comments and concerns regarding the proposed project from the general public. The comments are transcribed by a court reporter for later reference and become part of the case's public file. While these comments do not become part of the evidentiary record, under Vermont law, the commission's decision must be based upon the evidence presented by formal parties during the evidentiary hearing. Public comments play an important role by raising new issues or offering perspectives that the commission should consider and ask parties to present evidence on. And the public hearing notices are made at least 12 days in advance to give ample opportunity for members of the public to attend or submit comments on their behalf. So the discovery and pre-filed testimony section. The petitioner files written testimony and exhibits with the original request for a certificate of public good. Other parties are provided the opportunity to file written testimony and exhibits after an opportunity to ask the petitioner about its filing during a process called discovery, which I'm going to explain in a little bit. And before the evidentiary hearing, this is done. Parties' ability to present evidence is generally limited to their pre-filed testimony and exhibits. Any factual matters that a party wishes to convey to the board must be contained in its pre-filed testimony and exhibits. Witnesses who provide testimony should also provide some basis for the opinions they express. For complex cases, there may be additional rounds of testimony to respond to what other parties have submitted. This is referred to as rebuttal and surrebuttal testimony. The scope of pre-filed testimony is narrowed with each round of testimony such that it may address only the testimony filed in the previous round. While rebuttal and surrebuttal testimony is normally submitted in the same manner as pre-filed direct. Sorry about that again. While rebuttal and surrebuttal testimony is normally submitted in the same manner as pre-filed direct testimony, there are occasions when such testimony is conducted live during the evidentiary hearings. And discovery is an opportunity to ask parties about what their witnesses have said and the exhibits they have provided. Discovery can be either written, called interrogations or requests for information, or oral, called depositions. Written discovery is served on parties by mail or by hand, and parties may also agree to conducting discovery through email, and is typically in the form of written questions. So, example, what is Mrs. Smith's basis for her belief that ... or document requests such as, please provide all the documents Mr. Johnson relied on in coming to the conclusion that ... Depositions are an opportunity to ask questions of other parties' witnesses before the hearing and outside the presence of the board. In certain circumstances, transcripts of depositions can be entered into evidence at the hearing. The purpose in asking these questions is manyfold, including understanding a party's position, formulating responsive testimony, and preparing cross-examination. When a party has good faith reason to believe that it does not need to provide answers or documents, they may object to the question or request. At that point, parties are obligated under the Vermont Rules of Civil Procedure to work in good faith to resolve the dispute. If no such agreement can be reached, parties may go to the commission for a resolution of the issue. Discovery is not automatically part of the evidentiary record, although parties may seek to introduce it as evidence, either in pre-filed testimony or seeking to introduce a witness's written responses to discovery questions during the cross-examination of that witness. So the technical hearings and briefs. The evidentiary hearings are very much like a trial, except that testimony is pre-filed in written form in advance of the hearing. During the evidentiary hearing, the pre-filed written testimony is entered into the evidentiary record under oath in lieu of it actually being given live at the hearing. During the evidentiary hearings, witnesses are called to testify under oath and may be cross-examined by parties and the board. Unless specifically authorized by the board, parties may not use the evidentiary hearings to provide new testimony not already included in their pre-filed testimony and exhibits from their witnesses. So the briefs, at the close of the evidentiary hearings, parties may file briefs with the board. Briefs are not evidence. Rather, they provide the parties an opportunity to cite pertinent facts from the record, cite applicable statutes, rules, regulations, and precedent, and explain their position for the board to consider, including in the final order. Typically, 2 rounds of briefs are filed, an initial brief and a reply brief. A reply brief, if needed, is limited to responding to arguments raised by other parties in their initial briefs. It is not an opportunity to raise new issues. And then after all of that, if we get to this part, the commission will issue their decision. So once the evidentiary hearings have been completed and the parties have been given the opportunity to submit briefs, the commission will issue a decision. This is called the final order, and it must be based on the evidentiary record and will include findings of fact under the Section 248 criteria, including the incorporated Act 250 criteria, as well as conclusions of law. If the board does not hear the case directly, the hearing officer will issue a proposal for the decision. Parties will then have the opportunity to file written comments on the proposal for decision and ask for oral arguments before the commission. The proposal for decision and any comments on it are submitted to the members of the commission for review. Sorry, I gotta find my spot. Um, the final board orders are subject to motions for reconsideration under the rules of civil procedure. Any final decision by the board may be appealed to the Vermont Supreme Court, and any appeals from a board order are governed by the rules of appellate procedure. In the criteria that I mentioned a couple times throughout this section, so the Public Utilities Commission considers 11 statutory criteria when it comes to applications. First of all is they take into consideration the orderly development of the region, the need for present and future demand for service, system stability and reliability, economic benefit to the state and residents, and all of the environmental criteria from Act 250 except criteria 9B, which is related to prime agricultural soils. And many of you are familiar with the criteria from Act 250, and that information is available on the Public Utilities Commission's website. Case law is still evolving around the Section 248 process. Some key cases are the Northwest Vermont Reliability Project, Chelsea Solar out of Bennington, and the Cold River Reconsideration and Appeal out of Rutland Town. So Act 250 has a lot of case law around it since it has been around a while. Section 248 has not been around as long as Act 250, so there's still a lot of case law to be had to determine how these criteria are weighed in projects. Right, and then a couple more slides. So that was a lot of information in that one section. So I'm just gonna unmute it really quickly. And all of this information is of course available on our website and the Public Utilities Commission's website. But are there any glaring questions out of this section before I proceed?
How does all this relate to if a landowner just wants to put solar or something on their roof?
Yeah, so that would be a net metering project, and they would file an application through the Section 248 process. They may not necessarily go through this entire process that I laid out. This process that I just laid out is more for those really large scale utility projects, but they do have to get a certificate of public good from the Public Utilities Commission. And sometimes that can get denied. Sometimes it's accepted. It depends on the area of the state.
Wow. And how does wind play in this?
Yep, so it is the same rules for solar and for wind. So if someone wanted to put a tiny wind tower on their house, for example, that still goes through the same net metering rule as solar. I believe they would have to get a certificate of public good, and that's if it's tied into the grid. None of this applies to off-grid home for home use only.
Okay. Well, at one time, as I understand it, an individual could go to the Public Service Board and get their own approval and bypass the town. And it sounds like all these new acts have closed that loophole. Is that right?
Sorry, can you repeat that?
It used to be that an individual could go to the Public Service Board and get their own approval for a wind tower or whatever, and they didn't have to consider what the town thought about it. Where does that stand now?
I believe that depends on the size of the project. If it's below 15 kilowatts, the town does not get involved. But I think if it's between 15 and 150 kilowatts, then the town will get the notice. And what I've seen is typically the town doesn't get involved because it's usually just solar panels on somebody's roof. So usually those are not as controversial as the bigger arrays or wind towers that we see in the state.
Thank you.
Welcome. Sorry, is there any more questions before we just finish the last few slides? Okay, hearing none, I will continue on. So I went through briefly what an enhanced energy plan is. Oh, sorry, there is a question. So the question is, why, given this arduous process, would you want to get involved in enhanced energy planning? Really, the purpose of enhanced energy planning is so a town can have more of a say in where, you know, they would like energy development or not like energy development in their community. So, for example, if a developer came and wanted to do a 10-acre array in a town and they didn't have an enhanced energy plan, then the town doesn't have as much say as they would if they had an enhanced energy plan. The way that we are interpreting statute is if you have an approved enhanced energy plan, then the Public Utilities Commission is going to look at your policies in your plan and use that as, you know, in the record. So if you say you don't want a 10-acre solar array in one part of town and that's where it's proposed, then the project is pretty much dead because you're not giving that a preferred siting status, versus if you didn't have your enhanced energy plan, then you couldn't do that and you might have to rely on the Regional Planning Commission to issue that letter for you, or hope that the Public Utilities Commissioner is going to take your opinion into consideration. It is very arduous. I totally agree with that. These energy plans are, you know, they're big, there's a lot to talk about, but I do see a benefit to it, especially if we're all trying to reach these energy goals in the future. Okay, so writing effective enhanced energy plans for use in section 248. So effective energy plans. The Vermont Supreme Court has emphasized the statutory requirement relates to orderly development of the region, not to a particular municipality within the region. And that was in the Rutland Renewable Energy Supreme Court case in 2016. So due consideration, which I've thrown that term around, this is a phrase in section 248B1 of the Vermont state statutes. At least impliedly postulates that municipal enactments in the specific area are advisory rather than controlling. So in plain language, that means due consideration means that the Public Utilities Commission is not bound by municipal or regional pronouncements or enactments, basically your policies. Rather, in evaluating whether a proposed facility will unduly interfere with orderly development of the region, the Public Utilities Commission must consider certain municipal and regional recommendations and municipal plan provisions related to land conservation. However, the consideration that the Public Utilities Commission must give to these factors is a matter of broad discretion. And if you have an approved enhanced energy plan, then you get what is called substantial deference. So under Vermont State Statutes Title 30, Section 248B, substantial deference means that a land conservation measure or specific policy shall be applied in accordance with its terms unless there is a clear and convincing demonstration that other factors affecting the general good of the state outweigh the application of the measure or policy. In plain terms, while the Public Utilities Commission has broad discretion in evaluating municipal and regional recommendations, if you have substantial deference, this limits the Public Utilities Commission's ability not to enforce a specific municipal or regional conservation measure or specific policy in particular circumstances. Such as where the municipality or regional planning commission has received an affirmative determination of energy compliance. So that is where the difference is, and that's kind of the allure to the Enhanced Energy Plan, is to receive substantial deference. So if you do not have an Enhanced Energy Plan, then the Public Utilities Commission will look at your plan as a matter of broad discretion, where under substantial deference, they have to look at your policies. And both of these are still evolving through case law. These are mostly interpretations of statute that we've received down from the Public Utilities Commission. It's not defined in statute yet or in case law. I think eventually they will be defined, and then we'll be better able to understand what these two terms mean. And how can your energy plans be effective? So for example, the timeliness and the extent of municipal and regional participation in certificate of public good proceedings may be important factors in the Public Utility Commission's due consideration or substantial deference calculus. The reasonableness of municipal or regional recommendations and the basis for those recommendations are also important factors influencing the weight that the Public Utilities Commission gives to municipal and regional recommendations. On the other hand, recommendations premised only on demands for strict compliance with land use and zoning requirements are far less likely to be adopted by the Public Utilities Commission than recommendations that are based on well-established and specific planning goals. So for ground mounted solar, under statute, such facilities are required to comply with screening requirements contained in a municipal bylaw or ordinance and with the recommendations of a municipality applying the bylaw or ordinance. But the bylaw, ordinance, and recommendations must be fundamentally reasonable. So for land conservation measures, the Public Utilities Commission found that such measures are those that are specifically directed toward land conservation and not general policy statements that apply indiscriminately throughout the municipality. Therefore, it is critical to identify areas and resources intended for conservation as specifically as possible, including through mapping in municipal and regional planning documents, and to use mandatory language as appropriate to help ensure their protection in a 248 context. And mandatory language is in your policies, your shalls and your musts. But however, given the statutory requirement that any policy be specific to receive substantial deference from the Public Utilities Commission, it is reasonable to conclude that the Public Utilities Commission will analyze asserted specific policies in a municipal or regional plan in a manner similar to its analysis of conservation measures. So there are several resources that I mentioned throughout the webinar. Our website, we have a whole section on energy and on Act 174, Enhanced Energy Planning. The Vermont Public Utilities Commission has a lot of links on their website to try and explain the process in plain terms. I'm going to be posting this webinar on our YouTube page, and I will be sending that out as a potential resource. And as always, I am available either by